Welcome, everybody, to the Lawyer Show. I am your lawyer, Jeremy Rosenthal, and today my co-counsel is Robert Tobey. The Lawyer Show is a weekly podcast that we do, that I've been doing kind of since the pandemic, and I've done it for various reasons. Courts are picking up again. I've joked before that it's something that's kind of kept me off the streets. Just a few things I kind of want to share. I don't do a monologue so much, but I like talking. That's why I do this. One of the reasons, probably one of the best things that I've found about doing a podcast is that if you ever want to know your verbal crutches, you ever want to know what your pauses, what your hesitations are, how you do things incorrectly, doing this is just a fabulous way to have your friends and family members say, you say a lot.
That can happen, Jeremy. Or next. That's my favorite. I say next.
Next. There was one, I was in a CLE a couple of weeks ago, and a very good lawyer, very talented lawyer, who I will not name. I love her to death. She is wonderful. Another lawyer leans over to me and says, "Do you realize every other word out of her mouth is right?"
Then that's all you hear.
And then yeah, she may have taught me the riddle of the Sphinx or the meaning of life in her CLE. I didn't get it. All I heard was right. That
is what you hear.
Now, another benefit that we have is, being attorneys, you probably read a lot of transcripts. I read a lot of transcripts.
I do.
So in those instances, hopefully you get a good court reporter who can cut out your ums, ahs, okays. Do you find that that's the case? Do you get a lot of help there?
I don't get as much help as I'd like. When I read back the questions, and especially if it's the first deposition I've taken in months where I'm a little rusty, I find all kinds of things, and I'm like, oh my God, I can't believe this was me.
I hate reading my stuff. I will always invariably remember one or two highlights that from a proceeding or something. And by the way, in criminal law, if you're reading a transcript from a trial, it's because you lost. When you win the trial, the state doesn't have a right to appeal necessarily. And so reading transcripts isn't always a wonderful thing, although there's a lot of preliminary matters and a lot of other reasons why we have them. Of course, I never lose. I mean, that's...
Of course not.
And
all your clients are innocent, right?
Look, great question. They may not be innocent, but they may be not guilty.
Okay, fair enough.
Big difference.
It's an important distinction.
It is, right? And it's like, well, with the transcripts, see, there was another that now, and then that's just going to throw me in the ditch. But with transcripts, I invariably remember two or three real good highlights where I'm like, God, I'm like Shaquille O'Neal here, just jamming the ball. I am the man. And then I'll go through and read it. It's never quite as good on paper as I remember it.
It is never as good. You just hope it sounds better than it reads.
Right. Or you can condense it for whatever motion or however you're going to plug it, right?
Exactly.
And I know everybody watching just loves two lawyers nerding out on their transcripts. That's why you tune in, right? I mean, there's probably lawyers watching, but then again, maybe not.
It's pretty exciting stuff, right?
This. If this doesn't get your heart going and pumping, I don't know what will.
Right.
This is why you went to law school. I went to law school so I could read transcripts and just go through my highlight reel, and yeah, a lot of fun. So let me introduce my guest today, my co-counsel. His name is Robert Tobey, and Robert is very interesting on a number of fronts. Robert is the outgoing president of the Dallas Bar Association.
I am the immediate past president this year, Jeremy. It's a great title to have.
Well, the Dallas Bar, we're going to immediate past, right? You found somebody to take it over. You also are about to become a director in the state bar.
June 16th, I think I'm sworn in. So
okay,
a new challenge.
We're gonna get there. And speaking of new challenge, see, and this is a trigger point that I don't know that you've walked into here. I am a Red Raider. I know you are a Longhorn.
Absolutely.
And you stole our coach for basketball.
Well, he was coming home, Jeremy.
I will.
He's coming home.
If you want to apologize, now is a time to do it forever. And what he said, when he said to our athletic directors, he says, "I'm ready for a new challenge," and so that's you just now other triggers of mine. Baylor Law School, which you didn't go to Baylor, but also Tarrant County, and we can get into Tarrant County if you want, because I don't know. Do you find that Tarrant County says when you're in Tarrant County, they're the friendliest place in the universe to practice law? Do you ever get that?
I've heard that many times.
And in your professional opinion, sir, is it?
It depends upon who you have with you.
Mm-hmm.
If you're from Dallas and you have the right person with you, it's the friendliest
From
place
Fort Worth.
An 817.
Right.
You need an 817 with you.
My theory is that they're not mean. It's not bad. It's not a bad place to practice law. I just find that they're like everybody else, but they're the only ones who go, "Oh, we're friendlier." I mean, and they may have coffee in the criminal cases. They may have coffee in the docket room. They're very friendly until you start winning or until you set your case for trial. That's where the claws and the talents come out. But
tell you interesting sidelight on that. So we had a great 7-figure verdict in a legal malpractice case there. Oh God, it's probably been 25 years ago. Judge took it away from us, or he NOV'd us, and we went up to the Fort Worth Court of Appeals and got most of it back, not 100% of it, and then we settled it. We went back there and tried a case. We were on the defense, and we got hit for 7 figures in that case, and the Fort Worth Court of Appeals rightly took it away from the other side. But you know, those were 2 of the bigger verdicts we've ever gotten, were one on the plaintiff's side and once we got hammered with it.
Right.
And so the juries over there, if they find the right case, they will give money out. And you can't say that about every place in Texas.
Collin County?
Well, we won't go there.
Okay.
We are there, but we won't go there.
I get it. We're close to the Denton County line. We may be. Are we in Denton County?
Are we really? Okay.
I think not by much. I think we can be prosecuted either place. We're within 400 yards, and in fact, fortunately, police will file in the wrong county, and we've been able to get some acquittals there. So
there you go.
You know, sticking it to the man. Litigating against the government is like it can be like, you know, the clown that you punch it's got the dumb face, and you just can,
and it just comes right back up.
You can hit that thing as hard as you want, as often as you want, and it will always, always, always pop up with that really dumb grin. And that's part of the magic of criminal defense. That's part of the magic against litigating against the government. But I want to talk about you. I promised you to come on this show. I said this will be about you. And then instantly you realize, as do all my guests, that no, it's about Jeremy and his phone number. Yeah. Okay, so you have so above and beyond some of the professional leadership that you've done, which is a story in and of itself and something that I want to talk about with you. You also have a very interesting practice, and you can obviously describe it a lot better than me. So go ahead, take it away.
We like to say that we prosecute people who steal from you with a fountain pen. You know, you prosecute or you defend people who might, you know, steal with a knife or a gun or something like that. Our adversary stole with a fountain pen. And what does that mean? That's usually lawyers, that's money managers, that's accountants, people who act either in a fiduciary capacity or are negligent. And it's an interesting practice. It's brought us a lot of interesting people to talk to and represent, and also a lot of interesting stories.
So for those who are not lawyers out there,
yes,
describe what a fiduciary is, and so essentially, as I understand it, well, I'll let you just kind of talk about what a fiduciary is, because that's kind of who that's who your practice really seeks to hold accountable. So tell everybody what a fiduciary is. What kind of roles do they play in people's lives, and what type of power do they have over people?
Yeah. So fiduciaries are people who are supposed to put the other person's interest above their own. It's the highest duty under the law. The metaphor we like to use when we go to court is that a fiduciary is like the Secret Service. And if a guy on top of a building has got a gun trained down on your client, that person is supposed to take the bullet for the client. I mean, that's a pretty powerful
Yeah.
metaphor to be able to give to a jury, and they understand it instantly. And fiduciaries are lawyers who represent clients. Stockbrokers are fiduciaries. When they take orders and execute orders on behalf of clients, that puts them in a fiduciary standpoint. A lot of times other money managers are. Anybody who handles other people's money, generally, that's going to be a fiduciary. And when those relationships are found in the law, they are held to the highest standard. And there's not a lot of forgiveness when they violate that fiduciary duty.
There's a lot of power imbalance in the fiduciary relationship. If I go to CarMax to buy a car, I, as a consumer, have enough power and enough knowledge in theory, although I'm not really good with cars. Maybe that's a bad example.
But you have the right to walk away.
I have the right to walk away, and I know, and I ought to know a good deal when I see it. I ought to be educated enough, and I know that what I'm getting from the salesman is fluff. When I go to
and CarMax can't make you buy their car, or they can't make you sell your car to CarMax.
Right.
It is a voluntary transaction. When you've entrusted your money to someone else, it's a lot harder to break that tie than it is to walk out of the CarMax without doing a transaction.
Right. And so in an instance like that too, a wealth manager, for example, or a physician, they tell me this is the right medication. They have far more knowledge and power and influence, because most folks are just going to say, well, you're the money manager. You're the money guy. You've been in stocks your whole life. I just have money, you know. So
that's exactly right.
So that's where a lot of that imbalance comes from. And so talk about the types of situations that you guys get involved in. Maybe some of the common ones, more specific disputes that you guys, and how do they present? How do they arise? Client comes into the office, you hear the same story, probably in different ways. Take us through how some of those might work.
So we're blessed that our phone rings a lot. We're also cursed that our phone rings a lot. We spend a huge amount of time screening calls and stories and allegations from potential clients. We call them PNCs, potential new clients. That's our acronym for them. And when PNCs call, they all have a story to tell. And they all, I'd say 80%, can allege a mistake by the lawyer or the money manager or the accountant. That's really the easy part. And they call in and they allege a mistake and they think, I've got a great case. Well, that's where your case starts. We take it as a given that the lawyer or the money manager or the accountant made a mistake. It has to make a difference. And that's the part that most potential clients really have a hard time grasping. And even a lot of lawyers who send us cases have a hard time understanding that. So not only does the lawyer or whoever it is have to make a mistake, but it has to make a difference in the outcome. And I'll give you a good example. You have a car wreck, and there's a 2-year statute of limitations to sue for your damages or your injuries, whatever they are. And if you wait 2 years and 1 day, your claim is barred, and it's barred forever, even if it's only 2 years and 1 day. So if the lawyer gets the case, say, with 6 months left in the statute of limitations, but then does investigation or whatever, or forgets about it, that happens, and the lawyer then files suit 2 years and 2 days after the wreck, the claim is barred. So the client comes to us and says, well, the lawyer blew the statute of limitations. Okay, great start. Well, now let's look at your car wreck case. Well, it may turn out that the client ran a red light and hit somebody else. Well, that's a bad case. They were going to lose that case if the lawyer had filed it on time. That's a so what that the lawyer missed limitations. In fact, the lawyer may have done you a favor by losing quickly as opposed to taking 2 years to lose. So that's the part that clients really kind of struggle with, and that's the hard part of our job, is to do that analysis to determine whether the mistake made a difference.
So you're saying that the culpability may be off the charts, or the negligence may be off the charts, but if the damages aren't there, then they're not there.
Yeah, it's actually the causation isn't there. If the mistake didn't cause damages, it's not there. And then the damages themselves, That's also very tricky in our cases because a lot of times the client will come in with all kinds of damages, but they can't necessarily pin it to the mistake. And so that part could be hard.
And that would be, I think, particularly frustrating. One of the things when you're dealing with fiduciaries, right? When you're dealing with a lawyer, and not that I know any lawyers that are fast talkers. I don't know any of those.
There's no such thing.
I've never met one of those. But lawyers, a fast-talking lawyer, again, is in such a place of power over the client that, let's say the lawyer does blow the statute of limitations. The lawyer can try, in some instances, to kind of tap dance around that, maybe put a little lipstick on it and try to sell it to the client as, this wasn't so bad, and try to talk the client out of taking action. But even, do you see in certain cases, and does it make a difference if you have that degree of culpability if the causation isn't there or the damage model isn't there? Talk about that. Do you see that at all?
We do see that. And, it's the old axiom that it's not the mistake, it's the cover-up. And when you have a lawyer try to cover up whatever it is they've done, well, that gives a lot of oomph to the case that might not be there otherwise. Mm-hmm. And most lawyers we see are pretty good about, hey, I made a mistake, but it doesn't matter. Mm-hmm. This wasn't a good case. Or I had this defense, there was somebody else involved. And these are the hardest cases there are to win. And the reason being is we have to prove, in essence, 2 lawsuits. Going back to that car wreck example, we have to prove not only that the lawyer made a mistake, that's lawsuit number 1, but we have to prove the causation part, which is the part that shows that his mistake or her mistake made a difference. So every one of our cases involves proving 2 different lawsuits in one, and that's hard. And the other irony of these cases is, this might not have been a great lawyer. A lot of lawyers that we see are not really good lawyers. But when they have insurance, the insurance companies hire the very best lawyers in Dallas to represent these lawyers. So every one of these fights is a real fight against a really good lawyer. So, and they will come up with every defense known to mankind to try to get their client off the hook. And it's a dogfight every single time.
Because they're defending the holy grail of insurance money, which, God forbid, an insurance executive they're shivering on the streets and starving to death. You're watching JP, Kathy, and the Crew Network. This is the Lawyer Show. We're on between 12 and 1. You can watch JP, Kathy, and the Crew between 7:30 and 9, Mondays, Wednesdays, and Fridays. I want to talk a little bit about some of the accounting malpractice and legal malpractice cases that you do. We've been talking a little bit in some ways about that. You've been an expert witness before?
I've done it several times.
Okay, talk about that.
So in a legal malpractice case, the Texas Supreme Court has said only a lawyer can criticize another lawyer. Mm-hmm. And it has to be done as an expert witness. And basically, I couldn't testify as an expert witness that a patent application wasn't filed right because I don't handle patent applications. So we have to find, if we have a case involving a patent application, we have to find somebody who's an expert in that area. Now, I'm testifying as an expert in a case involving what I would call general negligence over the handling of the Dallas Police and Fire Pension Plan. And that's a really interesting case, and it's headed to trial in October of this year. So that case is so complicated and so detail-oriented that it's one of those things where you just sit down and it's like drinking from a fire hose every single day. So those are the types of things that we work on, but you have to have the right kind of knowledge to testify as an expert in any particular case. And that, frankly, is our biggest challenge in many cases. When you get into specialized area like corporate securities and a mistake is made there, you have to have the right exact expert. And those folks are hard to find because there's not that many of them. and they have to be willing to testify against another lawyer. And that's a struggle to find those folks a lot of times. So
something that I kind of that I think is interesting in particular, and I think I don't know if you find this to be a big challenge as professions go. You know, you are in many ways a rare breed, okay, because you are willing to pull the trigger on other lawyers.
We are rare,
and we like to think that, and I know, going to law school, doing the professional rules of the Texas rules of disciplinary conduct, and they really drill these things into our head. We like to think as lawyers that we're better at policing ourselves. I think we probably are, but not as much as we think. But when you talk to, I remember first year out of law school, before I was a prosecutor, I worked for a plaintiff lawyer, and we were trying to do medical malpractice. That you used to be able to sue doctors if they made a mistake. Yeah, that's another topic for another.
Until 2003.
And it's anyway. And there's a class, by the way, in medical school. I am convinced there's a class in medical school called Fear All Lawyers, right? Because I don't know about you, I call doctors for medical records. I just want to prove my guy had a bad knee. Okay, that's all I want to. They're paying their insurance deductible, and I got a lawyer calling me, and I'm like, no. What, all right, fine. You're that chicken s afraid of your shadow, then that's the deductibles, your idiot tax that you just paid. But it's hard to find doctors to testify against other doctors. It's hard to find lawyers it's probably easier, but not by a lot, to find lawyers who will be willing to do that. And I'll bet you dollars to donuts. Is that part of your challenge when you're in a really complicated space talking about this pension? There's only so many firms that I think can handle something like that, and only so many professionals that can do it. And then you call Joe Blow and say, I need an expert witness. He says, well, I'm not testifying against that guy. He was my best man. Do you run into things like that?
Well, you do in the specialized area, because a lot of times those lawyers work at big firms, and the big firms will not allow their lawyers to testify against another lawyer. So then you're faced with trying to find somebody at a boutique, a lot of times out of state. And that's a real challenge when you have to leave the state of Texas to go find your expert witness. And that does happen from time to time. So it is a challenge. Interestingly, you brought up doctors. Doctors are fascinating. And back in the joke that, I guess, not really so funny, but a joke that Jeremy and I were saying is in 2003, the legislature and then the citizens of the state of Texas voted a constitutional amendment to limit non-economic damages against doctors to $250,000, which led to many claims never being filed because it's not economical. But before doctors got that kind of a benefit from the legislature and then the citizens of Texas, they learned a lot of great loss prevention strategies. And one of those was to apologize. The effect of an apology is amazing. You know, if somebody makes a mistake, and we all make mistakes, we're all human beings, none of us are perfect. But if you make a mistake and you say you're sorry, the odds of somebody suing you go way down.
Right.
Statistically, it's fascinating. And that was one of the things that insurance companies taught doctors. Say you're sorry. That lowers the number of lawsuits out there. The other things insurance companies do is they keep a pretty tight hold on their wallet, and they're going to make you prove your case before they pay.
Right.
But it's really interesting. You know, those sorts of lessons were learned by doctors 20 years ago. And lawyers, I think, are starting to learn those same lessons today. It's the power of the word, I'm sorry.
Right. A great point. You know, one of my best friends, I say he's one of my best friends. I consider him a really good friend of mine, John Howie, who I know you know. And John Howie, I'm trying to get him on the Lawyer Show. I'm trying to get him on the podcast. If he's watching, he's not watching. He's working, because I've always said, John, can you come? Give me a Thursday you can come on. I'm so busy, I got $8 million for it. You know, he'll list out to me everything that he's got to do. But John's dad was a big plaintiff's lawyer.
He was a legend.
And he had a partner by the name of Paula Sweeney.
Yes.
And a quote, and I think it was John who told me this, that Paula was invited to the American Medical Association. They had that much, she sued doctors, but they had that much respect for her that they brought her in to speak. And she said to the whole room of doctors, wherever, I've never once had any patient come in that says, God, I love that doctor, but I just have to sue him, right? And so in my practice, that spoke volumes to me because I don't make mistakes. Other lawyers might, not me.
Of course not.
But I do, when I do make a mistake, I find that it's very, it's our natural instinct before you go to law school to apologize. But then you get in your brain head, oh, we're going to get in trouble if we just are nice people. But in reality, do you find that's the case across the board with some of your other folks that you sue, a money manager or other fiduciaries? And you don't get into fee disputes as often, do you, when you're at least polite?
Politeness is an amazing tool in the defense arsenal. It is an amazing tool. It is so powerful. But I think it's more individually driven than it is, this group never says they're sorry or this group always says they're sorry. It's really the individual, and it says a lot when the client comes to you and says, well, the lawyer said they were sorry and you should pursue a claim against me because this is what happened. Mm-hmm. And the reality of it is, I'm not going to say, well, maybe half the time the mistake can be fixed. And so if you tell the client, yeah, this happened, but there's probably a 50-50 chance we can get this mistake fixed. We can file a motion with the judge to allow us to designate this expert late, or whatever the mistake was, chances are it gets fixed and there's no harm from it. And if you're candid with the client, you build strength into that relationship that's not there otherwise, because a lot of times the client's hired you based on a recommendation from somebody else as opposed to their having personal knowledge about your abilities. And when that happens, they can look at you and like, okay, this is my warrior. This is who I want fighting for me in this case. And it just makes a huge difference.
One of the things I like about criminal defense is you can't lose if you're not there.
Right.
So you can't there's no default judgments in criminal law. So the mistakes if we make mistakes in criminal law, like you're saying, the vast majority are very fixable. No mistake is going to be, there are times when a client might say to me, and they always say it, and you get that note, you probably get this too. You're in trial and your client is just writing emphatically and they shove you a piece of paper and it's like, ask about the dog. Right?
Yeah.
And so there's mistakes and there's mistakes. And then you've only been working on the file for a year and you've got boxes out the wazoo and you're like, the dog, nobody cares about the dog, but the client's like, ask about the dog. And so that takes a little bit of finesse. I'm sorry that you're upset. I really, in my professional experience, I don't feel like that's very germane. Every once in a while, I'll give in. Tell us about the dog. And I always regret it too.
Always. Yeah.
I'm like, oh crap. Well, that's because your client,
Never a good idea.
So we don't ask about the dog.
But here's one aspect of the criminal lawyers in this area have it. Talk about difficult to sue lawyers generally.
Yes.
Criminal lawyers in particular, because I was talking about in the car wreck example how you have to show it made a difference. With criminal lawyers, if someone claims, for example, that the state offered them a plea, and the lawyer didn't tell them about this plea offer, and then they wind up going to trial and getting sent away for much, much longer than the plea offer was. Well, the Supreme Court of Texas has said that the client, to win a legal malpractice case in that circumstance, has to prove actual innocence.
Are you ready to be impressed beyond your wildest belief?
Yes.
Peeler versus Hughes and Luce.
That's exactly the case. Yeah.
I shockingly
Every criminal
know.
lawyer should know that
Thank you.
case.
Yes. Shockingly, the criminal lawyer knows what keeps his. I was going to ask you one of the questions. I was going to ask you if you've ever had a criminal malpractice case.
We've never taken one. We certainly had people call and claim their lawyer made a mistake of one sort or another, and basically, most of it is bad bedside manner. That family law and criminal law have a lot in common. The lawyers oftentimes don't really like their clients very much.
Not me.
I'm sure you like all your clients, but
their families can be a little challenging,
well,
but the clients are great.
Yeah. Ike Van den Eyck had the best quote, and he said that criminal lawyers see bad people at their very best, and family lawyers see good people at their very worst.
That's absolutely true.
And I wish I had come up with that quote, but that's Ike's quote, and it's really very, very good. So you do see people, they're either not very good people to begin with, or they're on their absolute worst behavior in those two areas. And it's not surprising that lawyers don't like talking to them because they're unpleasant, or they don't like communicating with them in one sort or another. That's what gets most lawyers in trouble, is that bad bedside manner of not telling your client what's going on.
So what is first off, you're watching JP, Kathy, and the Crew. You can watch JP, Kathy, and the Crew on, you're watching the Lawyer Show, rather. You can watch JP, Kathy, and the Crew, because this is the JP, Kathy, and the Crew network, between 7:30 and 9, Monday, Wednesday, Friday. This is the Lawyer Show. We're on between 12 and 1. I'm Jeremy Rosenthal, your lawyer. This is my co-counsel, Robert Tobey, today. In criminal law, what we do have, we actually do have an equivalent, although it's not going to be for money. We have claims for ineffective assistance of counsel, which can be very, very bad for your law license if you get too many of them, and it can really limit your ability. It can limit a lawyer's ability to take certain kind of appointments if that's what's important to them. Our firm, and I'll tell you this, one thing that we have in common is that our firm, we do handle ineffective assistance of counsel claims. And so what will happen is, a client will come in, or their family will come in, and they will say, here's what my lawyer did wrong. Here's all the things that they did wrong. And yes, there's a two-part prong, which kind of mirrors some of the malpractice stuff. One is that it has to fall below the reasonable standard. And the case is called Strickland v. Washington. Number one is it has to fall below the reasonable standard, which in some instances, very rare to have a per se violation of that, like a blown statute of limitations. But we can, you can fail to make the right objections at the right time, and you could probably point to losing the case for that reason. And then there has to be a causal element there. It has to cause you to have your situation worsened in whatever regard. But those are, and so I find that, and I don't, and the lawyers on the other end of those, I hope they understand that this isn't personal. I don't care whether they think it's personal or not. When you have a client who's
But you have the knowledge that they will always consider it to be personal.
That's life.
Yeah.
And if you can't handle that, then you don't be a lawyer.
It's the rare lawyer who doesn't take it personally on some level.
And if somebody, I can understand that. And not only that, I think you also get a lot of, in these instances, you get them too. I'm sure you get the Monday morning quarterback, which is the reasons that trial counsel gave turn into strategical reasons later. Well, why didn't you call any witnesses in punishment? Well, that's because, no, you just weren't ready. You didn't have an expert lined up in this area. You knew, or you ought to know, when you handle this type of a case, that this is going to be how the state's going to proceed here. You didn't handle that correctly. But it doesn't matter to the client. The client and the client's what matters. There are a few tripwires. Immigration can be a very big tripwire in criminal cases. Also, the big tripwire is failure to investigate. When a lawyer doesn't investigate a criminal case, that very often leads to ineffective assistance of counsel. But I want to get back to, there are some important things I want to cover with you. Are fee disputes more common these days?
They are, and it seems like they're growing in numbers every year. It used to be the big firms really didn't want to get their hands dirty with trying to collect fees from clients. That's changed. The economics after 2008, with the crash in 2008, everything changed. Law practice, I tell audiences when I speak, there's the old practice of law before 2008, then there's the modern practice of law and since then. And now I guess there's going to be a new normal once the pandemic is fully over in a few months.
You're in Collin County. It ended here like in last March.
Well, it's kind of ended for me after I got my second shot, but it has that feeling at least. And so there's going to be changes as a result of that. But the big thing was the stigma of suing for fees went away. And statistically, if you sue for fees, there's about an 80% chance that the client will file a counterclaim for malpractice or breach of fiduciary duty. So
the very first, to cut you off just for a second, when I first applied for malpractice insurance, that's question number one.
Right.
That's question number one.
Have you ever sued for
fees? Do
you
sue clients? So, but I'm surprised to hear that firms have said we're still doing it.
They have, and because certainly after the financial crisis, it wasn't unusual to see $1 million bills. I mean, that's a lot of money to walk away from.
Yeah.
And so firms are doing it now, and with the knowledge that they're either going to get threatened with or sued for malpractice as a counterclaim. So we're handling a lot of those cases on behalf of clients and on behalf of law firms. We're being hired by both sides, and it's an interesting dynamic, to say the least. And we handled a case 3 or 4 years ago. It was an intellectual property case, a patent case. And the fee dispute was over like $1.4 million. It was a lot of money the lawyer was suing for. It was such a complicated case, and it had been litigated in federal district court in San Antonio. Then it was appealed to the federal circuit in Washington and came back. And, there was just lengthy proceedings over many years. And the lawyer in that case, there were 40-hour billing days. I mean,
that's a little.
Does that sound like more than 24?
I went to Texas Tech, so that's going to take me a minute.
Yeah.
But
I think your math's right. but he had his staff, and he had all these lawyers working, so you would have 40, 50, even 60-hour days working on this case. And, was there repetition? I mean, when you have that many hours billed to a file, it's impossible that there's not repetition, that there's not wasted time, there's not wasted effort, there's not overbilling, perhaps even intentionally. But the thing was, it was so labor intensive to go through these bills and analyze them and determine maybe what a fair fee was going to be, that we wound up settling it for about $700,000 relatively quickly, because we already had $200,000 or $300,000 of legal fees in it ourselves. And so you start to do the math, and even a very large fee dispute becomes uneconomical in a hurry. So that's one of the things that clients need to understand. Yeah, maybe the lawyer overbilled, but the cost of pursuing that can swallow up your savings.
But don't they file, I mean, depending on how personal it can get, isn't one of the plays to file a grievance along with your fee dispute, or along with your lawsuit, or along with a fee dispute or a malpractice claim? Well,
let me explain the grievance process, because that's a really good question. The grievance process is designed to punish lawyers who have acted unethically. It is not designed to give you a malpractice recovery. It's not designed to put fees back in your pocket. It won't do any of those things. But if the lawyer's acted unethically, the lawyer can be punished. And that can include anything up to disbarment, so taking the lawyer's license away. No, they're not going to take the lawyer's license away for a fee dispute. But the problem with the grievance process and working alongside the civil litigation process is the grievance process is not handled by you. It's handled by the state of Texas if they decide to pursue it. You totally lose control over that process. It's really up to the state. And if the state kicks out roughly 85% of all grievances that are filed as being what are called inquiries, which don't go anywhere. So you fire that shot and you miss, well, there goes a lot of your leverage right there. So we are very wary of filing a grievance at the same time.
You've probably got to have a hard talk with some of the clients too, because I'm sure they want to get after that.
And a lot of times they've already filed one. They come to us, they've already filed a grievance. And I'll say, well, I guess we'll just sit and wait and see what happens with your grievance before we even discuss whether to take your case or not.
Let's step back a second and let's go back to some of the fiduciary stuff. Folks who are watching, what are red flags when it comes to a fiduciary?
Red flags are unexplained fees, failing to explain what they're doing. They should have full disclosure early and often. And if you're not getting that, make sure you demand the information. Because there's a tendency, I look at doctors will bring doctors back up again.
No, let's kick them around a little bit.
Well, no, this is actually in their, in their favor.
Okay.
And I have to be careful. My dad was a doctor before he passed away. My brother is a retired cardiologist. So I'm a little more understanding of the doctors than some people are. But doctors, you think about it, you got ticker trouble, you go to them, and they say, here's what we're going to do. We're going to open you up. We're going to replace that blocked valve with a pig valve. We're going to sew you back up, and you're going to be okay. And all you have to do is sign this form here, which is the patient consent form, which has all the potentially horrible side effects of this surgery. But you do it. And so doctors are used to having patients trust them. They are the ones who trust money managers more than any other segment of the population because they're used to being trusted. They are trusting. And doctors, I find, are the ones who don't check more than any other group. And when it's the most important thing to do, if you're not getting that disclosure, you're not getting it early, you're not getting it often, you ask for information and maybe your calls aren't returned promptly, those are huge red flags when somebody else is holding your money. And we had a case years ago, probably the best case we've ever had. We represented some ultra-wealthy Mexican nationals that they were the principal owners of Telefonos Mexico, the AT&T of Mexico. I mean, to say they were wealthy is a gross understatement. They had a money manager in Austin, Texas, and what he did was, and they told him, his instructions were, do not lose our money. So what did he do? He lost he lost a lot of their money. And well, it wasn't that. It wasn't stealing. He invested it and wanted to be a hero and show them how he'd made all this money, but he lost a bunch.
Okay.
So what he did was he created fake statements that he mailed to them that led them to believe they were making money this whole time.
Little Bernie Madoff action.
It's
pre-Bernie.
It's pre-Bernie and worse, actually, or on the same level, I guess. And he did this until they finally said, we've got a major investment we need our money. Uh-oh. That was the O-defecation moment there. He didn't have the money. And so, but they never really questioned him. You know, they were getting these statements month after month, these fake statements. They were trusting him. And the key is, if you ask for information and you get an explanation that doesn't sound right or sound reasonable or sound smart, that's a huge red flag. So, and my advice is never trust anybody completely. Trust but verify is the expression.
I have a and it's interesting, highly, highly fascinating. So you're watching JP, Kathy, and the Crew Network. This is the Lawyer Show. We're on between 12 and 1. You can watch JP, Kathy, and the Crew between 7:30 and 9, Monday, Wednesday, and Fridays. So kind of bringing this all full circle. So let me kind of explain to everybody how I first met Robert Tobey. I was a young court-appointed lawyer once on a case that involved a client who was accused of stealing from her her parent-teacher association. And it's interesting too because this client is now deceased, and I've gone back and I've wondered oftentimes on the lawyer show what I can disclose and what I can't about certain cases, because we have, I mean, the things that our water cooler talk in our office is absolutely positively nuclear relative to what other folks may think, and we often chase away people who come and they think it's going to be a fun job for a few days, and we just kind of like we have to, everybody looks at each other, this one's not ready for that yet. But talking about her situation, I think I can talk about a lot of it because a lot of it was public record.
Yeah.
So she was alleged and was convicted of stealing from her own parent-teacher association, and Robert had actually sued her civilly,
yes,
for that, and then the matter was severe enough to where it got brought. It got brought criminally. I've represented a number of bookkeepers defending cases where the fiduciary is in charge of the books, and they are in and what will happen is businesses, small businesses, probably medium and large businesses. I mean, these folks in Mexico, right? I'm sure that there's no reason why they ought to have all of their information or money in a silo, which I don't know that they did.
They didn't.
But what happens is you get one bookkeeper, and that person has such extraordinary power. And if they are manipulative, if they're going to steal. Now, in my case, the evidence which came into trial was that she was potentially writing checks to herself in certain amounts that went kerplunk in her bank account the next day, a bunch of different times. Very challenging case. A lesson that I have learned, and I was going to tell you kind of before we got going, because this is what I remember about it. Prosecutors are really wonderful people. I love them. I don't know that any of them care enough to watch this. You know what? I also don't. Well, I do care what I say. I won't name names. But it's very interesting because I did keep the jury out on this case. I mean, this was a slam dunk against my client. But I kept the jury out for about 4 hours, maybe 5, on the one issue of did she write the checks in Dallas County or Collin County? Because it really wasn't clear, and the investigation was just like, well, look, here's all the bank statements. Look, she's guilty. Which, was beyond a reasonable doubt, and the jury agreed. But it went from, God, Jeremy, you're the prosecutors. You really fought for her. Thanks. You make the system. Thank you. You're a good lawyer. You made the system of justice work, and good job. Not much you could do here. To 2 hours where they're not talking to me. Then the jury's out 3 hours, and they're not talking to me. And after about 4 and 5 hours, the jury's still out. They're like, you're a trickster. You're a son of a bitch. How can you do this, that? And not to get too far into the weeds, I don't trust anybody. I don't trust anybody because of my experiences in this arena with bookkeepers. My grandfather ran a typewriter store in Los Angeles. He had breakfast every morning with the same 3 or 4 guys. One of them pocketed about $300,000 over the course of a decade. You see that a lot, unfortunately.
Yeah, and just to talk about that case.
Yeah.
Here's what happened. I mean, she moves from somewhere, I don't remember where they came from, immediately gets involved in PTA, and in PTA they like to say it's the STET principle, same 10 every time. So there's the same 10 volunteers do everything. Mm-hmm. And she stepped in and raised her hand and volunteered to do all sorts of things and got her kids involved in the school, and she was willing to be treasurer. And funny enough, but that's not really a glamour job on the chain of command up to become president of the PTA. And she raised her hand. They trusted her. She was a great person, they thought. And they weren't watching. As bank statements came out, they weren't paying attention to what was going on. And she allegedly stole, and was convicted of stealing I believe it was over $80,000. It was a huge sum of money for
at trial. I believe I was able to show, or we were that there was no more than 57.
Okay, well,
but and this was another headache in the trial too, because the prosecutor didn't really. They alleged it. I remember this. We filed what's called a motion to quash, which is another way of saying you got to tell me a little more specifically what we stole. And I said, Judge, they're going to come to trial, and everything that was every paperclip, every pencil, every notepad that is gone from that school, they're going to accuse her of taking. No, we're not going to do that. And sure enough, of course they did. But it wouldn't matter for the punish. It didn't matter. But anyway, but yeah, no, she and I think to your point, we project our own values on other people. If I'm an honest guy, I think you're an honest person. If I if I would never steal from an employer, then, well, I'm just going to turn over the books to you, and I'm just not going to worry about this. And that's just a very alarming lack of institutional control, depending on the entity that you're dealing with, right?
Oh, it was shocking. Mm-hmm. It was just shocking, the length of time that it went on and the amount.
Right.
And it wasn't until they just realized, we just don't have any money, that something was wrong.
I think people were calling for your checks bounced, and that's how these, but again, and in situations like this, one thing I will tell any aspiring criminal defense lawyers is, if you represent a PTA person who's accused of stealing and they're out there, they make people angry, and the pitchforks and the torches come out after your client in mass.
I'll tell you, Jeremy, I filed that lawsuit, and 30 minutes later, Channel 8 called me.
Really?
For an interview. It was like, they monitor lawsuit filings, and they see, theft from PTA. Mm-hmm. That got on the news immediately. It was, and the reaction from it, after I was interviewed, I got called from all kinds of people all over the place. And, talking about the same lady, I got called years later from a woman in Malibu, California. So here we were, and
now this is my client, so I have to. I think I have to. Go ahead. Let's have it. This is
Malibu, California, saying she had gone out there and pretended to be a doctor, and apparently had run some kind of confidence scheme on them as well. And it was just fascinating to hear that. The old proverb of a leopard doesn't change its spots. There you go, back out and doing it again. So,
and a lot of what we do too is we try to, in certain instances, obviously we try to make the state prove it.
Sure.
If they're accusing it, and then we also try to get to the underbelly of the beast, which is if it's happening, why is it happening? What else is going on? Because this is obviously not normal. Before, and I told you, we email back and forth, and I've told every guest so far, I write a big outline, and it just, we get through a third of it. And it's because I'm talking about ridiculous stuff like Texas Tech basketball, and we, famously wasting time. But I do want to talk about how your, the issues that you've seen developing, and some different habits that you mentioned the 2008 had a big impact, and obviously COVID will. Talk about how COVID has impacted habits, practice of law, things like that.
Yeah, it's really fascinating, and it's sort of been an organic thing. And the thing about COVID is it happened so fast. And I'm thinking back, we made the decision to close our Bar Association building on March the 12th last year. And I thought, wow, we were way ahead of the game. Well, by the next day, the whole country was shut down. And so it happened on a dime, where 98% of the people who were going to offices are now working at home and gearing up as quickly as they can with home offices, good equipment at home so that they can print, they can scan. They've got 2 monitors on their desk to look at everything that comes in. And it worked shockingly well for the most part. Law firm productivity stayed up as we emerged from the pandemic, and people more and more are coming back to an office. There's going to be a segment of the population that never does, and that includes lawyers. They're going to stay home because they like it. Mm-hmm. people like me were going crazy. I couldn't stay home. I went to the office even when everything else was shut down.
Mm-hmm.
But there's 10, 15, 20% of the population is like, oh, this is okay.
It's all right.
I'm down with this. Well, what happens, though, is your communication with your legal assistants is not as good. The safeguards that you have of more than one pair of eyes being on a document,
Mm-hmm.
that slips, where maybe your pair of eyes are on a document but not somebody else's. Communication is not as good between you and your legal assistant, maybe your partners. And what we're seeing are those kinds of mistakes, missed deadlines, those sorts of things that would not normally happen if people were in an office.
You're talking about cases that are coming into you.
Yes. The
Right.
brand new, the COVID cases.
No, you're not saying if you call my law firm this, but these are unique challenges.
Yeah.
And so, but they have impact very real deadlines, very real rights.
Oh, yeah.
All that stuff.
And as people make that decision to stay home, the new normal will be not everybody's in an office anymore.
Mm-hmm.
I really don't think that's ever going to happen again, which is great. The traffic won't be quite as bad as it's been, and other things won't be as bad, but I think the quality will slip in a lot of instances. And so that's what I think is the trend that we're going to see, those sorts of mistakes. Again, you got to put it through the sifter, and does it come out the other end?
Right.
Did it make a difference? All those things are still the test, but
Mm-hmm.
it's a whole different ballgame than what it used to be. I mean, what we used to see, and this is obviously a very serious
Mm-hmm.
topic, but 30% of all lawyers are impacted by either substance or drug abuse or depression or some sort of mental illness, far higher than any other profession. Doctors are second, but not even really a close second to lawyers. And that's what you saw a lot of in terms of mistakes being made. You had lawyers who were impaired. You had lawyers who were in depression. You had lawyers who were suicidal. Big problem in the
Right.
profession. I think this is going to open up just more. I'm not impaired. I'm not depressed. I'm not suicidal. I'm asleep at the switch.
Right.
I think you're going to see more of that.
Heidi, our office manager, is here, and we have at our office what we call the river, which is a concept that I beat everybody down mercilessly with at the river, because all the information that comes into a law firm, I characterize it as a river. It's not a pond where it gets stagnant and it collects.
Better not.
That's when you get disease.
Yeah.
But it's a river, and everything has to find its home, and that could be on somebody's desk. It could be through somebody's file. But everything that comes in has to be processed in a certain ways. There are no miscellaneous folders. That's where things get lost. And we have a new river, basically, in essence. And so we've had to adapt in our office. Naturally, we've done it masterfully and better than any of our competitors. Which one's on? That one. I can point at the camera. I want to get into, certainly, because we've talked too much. I've talked too much. But I do want to talk about the year that you the year you earned the right to be the Dallas Bar Association president. And obviously the year did not go the
As
way
planned.
that you were thinking it was going to go when you signed up for it.
Yeah, and I tell you what, I had a lot of communications with our past presidents. They're a wonderful network of people. Helped me plan my year. I mean, one of the big things, we had an inaugural gala last January in 2020, January 11th it was. And, nobody in that room, 750 people of my closest friends, no one could have predicted 2 months later what was going to happen. And my big initiative was to celebrate the right to vote. The 2020 election was ongoing in terms of the campaign and everything else. And I was really excited about a set of programs for that. And we were going to do strategic planning with the Bar Association. And of course, that sort of took care of itself 2 months later. But the past presidents all told me, Robert, there's the year you plan for, and then there's the year you get. And never was it more true than 2020.
And with respect to them, and not to cut you up, but with respect to them, I mean, you got like, there's what's his name, President Buchanan in 1854. Then you get Abraham Lincoln, who gets the Civil War.
Right.
I mean, I kind of feel like that's what you got here.
Yeah, it was, Laura Benitez Geisler was my predecessor, president in 2019, and she had such a tranquil, fantastic year. I was like, wow, can it last one more year? And the answer was no. It lasted 2 months. But I had so many people say, wow, you got the short end of the stick being president in 2020. And I said, you know what? That's not really true, because we were innovating every day. We were reinventing ourselves. We were innovating. We were doing what we had to do to stay relevant to our members, to help our members every single day. And in a way, there's really nothing more you could ask for as president of Dallas Bar Association during that year. And it was fascinating, Jeremy. Is like, so we shut down March 12th. Our original reopening date was April 1st. And I literally thought 2 weeks, we'll hunker down. This will all be over. Of course, that didn't happen.
It did in McKinney.
Maybe.
No, I'm kidding. It really didn't even hear it.
I don't think
even.
Yeah, I think even in McKinney they acknowledged the pandemic.
Yeah.
But then there was a point in time where we shifted virtually, and it worked great, and people were loving it. We were getting hundreds of people on our videos, watching our Zoomcasts with CLEs and everything about COVID and all this. It was tremendously popular. And then Memorial Day, you have George Floyd, another seismic event last year that in and of itself, even if there wasn't COVID, George Floyd, in the aftermath of George Floyd, would have been significant enough to alter anybody's presidency. And it certainly altered mine. And what we did was we took a hard look at so many things. And I've got to tell this story because it's just so important to me.
The Lawyer Show is about stories.
Yeah. So our building is known as the Bilo Mansion, known for Colonel A.H. Bilo from the Confederate Army, who, after the Confederacy was defeated in 1865, he went to Galveston, bought a half interest in the Galveston Daily News, which at the time was the biggest newspaper in the state of Texas. He sent George B. Dealey to Dallas to found the Dallas Morning News. And he was the owner of the Dallas Morning News, and the Dallas Morning News was owned for 150 years by the A.H. Bilo Corporation. So this building that we're in was actually built technically by his wife, and he couldn't name it after his wife because women couldn't own property in 1900. That's where we were just 120 years ago. And we've never really looked at it in that way. The Bar Association bought the building in 1977. We had a huge capital campaign in 2001 to build the pavilion. And it's been known as the Bilo Mansion ever since we owned it in 1977. At one point in time, there was a portrait of the colonel in the building. And in 2017, when the controversy erupted about the Lee statue in what is now Oaklawn Park, was it then Lee Park, the Dallas Morning News ran an article talking about other links to the Confederacy and mentioned the Bilo Mansion. And at the time, we did some introspection. We removed the portrait and some other Civil War type artifacts. And then this year, after George Floyd, there was a controversy about removing an obelisk in Pioneer Park dedicated to the Confederacy. And the Dallas Morning News again ran an article talking about symbols of the Confederacy and mentioned the Bilo Mansion. And we underwent a real introspective period. We created an equality committee that was dedicated towards helping the legal profession find equality, and it's not there. I mean, we're working on it, but it's not there. We're working on helping with those efforts in the community itself, the community at large. And I'm so proud of that effort. And now, a month ago, carrying over from last year, the board voted to change the name of the building.
I didn't know that. What's the new name going to be? Do you know yet?
We are working on that process as we speak.
No reveal here today?
I could give you about 50 names that have been proposed.
Okay.
So there's a lot. There's a committee of 23 people, and I'm proud to be one of them. 23 very opinionated, very smart, very dedicated people who are right now working through the process, and our meetings are here in the next month. We're going to be reopening full-time around September 1st, and we're hopeful that we'll couple that with a marketing campaign to announce our new building name. And
the Robert Tobey Center
we've talked about
Justice.
We've talked about Tobey House.
Okay, I mean, look, it's got to be in the conversation.
you know,
I mean, if you got the year for Abraham Lincoln, if you've got the year of all the upheaval, I think I'm saying it may be talked about. I'm just saying.
And our current president is Aaron Tobin, so Tobin House, something along those lines. We've talked about that. But
I like it.
It may not make the cutting room floor, but we'll see.
We'll see. And one thing too that I think everybody needs to kind of recognize here that I've not really talked about. I mean, Dallas Bar Association is a big deal.
We have 11,000 members.
I mean, it is probably bigger than really any other. I'm lawyer push-up time. I'm on the board of directors for Texas Criminal Defense Lawyers Association, and we do have, I think statewide, I don't know, between 30 and 35,000 members, but that's statewide.
Yeah.
And we have there is a headquarters in Austin, but the mansion is extraordinary and it is exquisite, and you have had the opportunity to lead Dallas Bar Association at really, really a remarkable time. And my hope is that in 10 or 15 years, I think everybody is going to recognize that what the leadership that this time required was above and beyond. And I'm sure that they're going to acknowledge that's what they got.
Well, I appreciate that, Jeremy. We had a program almost exactly a year ago. It was our Law Day celebration. And I was the moderator, and we had 8 prior presidents who went through times of difficulty. We had one president talk about the days after the Kennedy assassination when the president of Dallas Bar went to the jail and met with Lee Harvey Oswald. America was ready to pretty much execute him on the spot, and there was the president of Dallas Bar who went and met with him and helped line up counsel for him. And we talked about efforts to integrate our bar with sister bars and righting some wrongs in history of our bar association with lawyers who had applied for membership who were never acted on because they were African American. And that's the 1950s. That's not so long ago in our history. And those types of things, it was just a very emotional program for me to hear what these presidents had dealt with during their years. And to hear from Harriet Myers talking about being the first at so many things, the first female president of Dallas Bar Association, first female president of the State Bar of Texas, White House counsel for George W. Bush. I mean, a true trailblazer. And just to hear those sorts of stories, it was phenomenal. And I like to think that we did a good job last year. I know we did. We're doing a great job this year exiting from this pandemic and making the changes we need to make this a more inclusive bar association and a more inclusive community. And it's it's the old Chinese proverb of, may you be cursed to live in interesting times.
No
we
kidding.
live in interesting times right now.
You think? Yeah, boy, what was the first clue? Yeah, no, you're right.
Something every day.
Absolutely. We are over time, but I do want to give you a chance to talk for just a minute about the State Bar and being a director in that. So,
the State Bar has had a lot of, I'm going to call them convulsions over the last few years. It has been kind of 2 steps forward, 3 steps back, 3 steps forward, 2 steps back type thing. And last year was the last 2020 leading into 2021 bar year. There was a lot of controversy over statements made by the president and inclusion and all that type of thing. And lawyers know what we're talking about. I'm excited by the opportunity to join the State Bar Board next month and to continue to work to pull the organization forward, to make it more inclusive for all lawyers in the state. And again, to make the State Board more responsive to the state of Texas as it looks in 2021, not how it looked in 1921, for example. it's really important that we do that we've got to mirror the society that's out there and bring assistance to those who need it. And so I'm looking forward to that challenge. It's coming up, and I know it's going to be an interesting process.
Yeah, it's very exciting stuff. I go, sometimes I'll go to, Collin County is a bigger place, not 800,000, 900,000 citizens, residents. And I want to say, too, that you go to other counties, you go to some of the surrounding counties, and you see pictures of their old bar association. Not a lot of diversity.
No.
And so the challenge is,
meaning not only women, it's all white men.
Oh, right, yeah.
It's
no,
all
it's
white
all
men.
It's men and maybe a handful of women, but all, and so very, very challenging things that and definitely a time for introspection. I think this is going to wrap up this episode of The Lawyer Show. I will say this, in the spirit of not having a fee dispute over this, I'm willing to waive my fee for the last hour for our audience. How about you?
I will do that, and I want to say thank you, Jeremy. When you approached me with this, I didn't know what to expect, but this has been a blast. I really, really had a good time with it.
Well, we'll have to do it again because this is we could have probably talked for another hour about this. Anyway, and I'll accept your apology about Chris Beard at some point later, maybe in the next show.
Yeah, after he wins us a national title, I'll be all apologies then.
Well, we'll accept it. Thank you, everybody.